SU. My Lord, parties are absent.
Appearance. Appearance. Yes. This case is for judgment. Appearance. Yes, counsel. Not you. The counsel online. Appearance, announce your appearance. Announce your appearance.
Good morning, my lord.
Good morning.
CSC Jere for the claimant.
You have to on your camera.
Very well, my lord.
For me to record you.
Very well, my lord.
Yes.
CSC Jere, I humbly appear for the claimant.
This matter, the judgment of the court is ready.
As court pleases, we are ready to take the judgment, sir.
The claimant was employed by the first defendant in 1990. He rose through the ranks to the post of chief lecturer in 2003 on consolidated revenue of 450,625 naira 25 kobo. According to the claimant, as at the time of his birth, there was no birth registry in his village where he was born. That's why he submitted a statutory declaration of age by his mother, showing that his date of birth was 18th day of February 1954. The claimant received, however, the claimant received a letter from Deputy Registrar Pension dated 19th day of January 2017, requesting for information from the claimant on the correct date of birth. In response, he stated that his correct date of birth is that which his mother deposed to in the statutory declaration of age. According to the claimant, he was retired prematurely, and it is as a result of this, his pension was not calculated appropriately, and he wrote petition to the ad hoc council committee on financial transactions of the college on his unjust retirement. The claimant solicitor wrote demand letter for payment of backlog of his salaries and allowances, and a reply to the claimant's letter, the defendant acknowledged the error made and their preparedness to pay claimant wrongfully withheld statutory salary and allowances. The defendant started making payment instrumentally and paid over 6.8 million, but abruptly stopped the payment. That's why the claimant approached this court, and by the paragraph 32 of the statement of fact, is praying for the following reliefs. One, a declaration that the purported letter of retirement which the claimant was compelled to write dated 13th day of March 2017, addressed by the claimant to the defendant notifying him of an early retirement date before his statutory retirement age of 65 is illegal and therefore null and void. Two, a declaration that the employment of the claimant was still subsisting until 18th day of February 2019. Three, a declaration that the claimant's purported retirement on 18th day of February rather than 18th day of February 2019, when he would have clocked mandatory age of retirement of 65 years is wrongful, illegal, and therefore null and void. Four, an order directing the defendant to pay claimant the sum of 1,054,240 being the total of his statutory and paid salaries and allowances for 7 months, August 2018 to February 2019. Five, an order directing the defendant to pay the sum of 1,897,471 naira, being the financial difference between 64 and 68% of the claimant final enrollment for pension. Seven, an award of general damages in the sum of 20 million naira, and 8, cost of this suit the sum of 3 million as cost of this suit. Upon being served with the originating process commencing this suit, the defendants on the 14th day of September 2021 filed the file a reply to the statement of defense and also the contact link. In proof of his case, the claimant testified as CW1 and called another witness, the legal advisor of the first defendant, who testified as CW2. The defendants on their part called one Boniface Iyembe, who testified as DW1 and tendered one exhibit in evidence. The claimants on their part stated that the claimant was retired in line with the College of Education revised regulations 2015. Upon his employment, the claimant presented a statutory declaration of age of 26th day of July 1983, putting his date of birth as 18th day of February 1952, and same date was reflected on his 2 curriculum vitae. In 1990, the claimant submitted another declaration of age dated 3rd of October 1990, purportedly sworn by his mother, showing his date of birth to be 18th day of February 1954, contradicting the earlier documents submitted. The discrepancy in the claimant's date of birth, due to the discrepancy in the date of birth of the claimant, the pension unit wrote to the claimant, in line with the extant rules, of terminal leave, abrupt retirement, and abrupt retirement. The dependent in response dated 25th day of April 2017 benevolently and on sympathetic ground offered claimant part-time appointment for 3 months to ameliorate his financial situation before commencement of payment of his benefit. By the letter dated 9th of April 2019, 2 years after his retirement and part-time appointment, the claimant continued with his inglorious course by writing through his lawyer demanding for immediate release of withheld salary. The dependent stated that by the undated letter, the claimant, the chairman of the governing council, requested for review of his retirement, and the committee found that the retirement was proper. The claimant denied the letter of 18th day of March 2019 as emanating from its record, and if it is so emanated, it is fraudulent, contrived, and concocted to defraud the first dependent, and it was not in total disregard, and it was in total disregard of the regulations. That based on the fraudulent advice, the first dependent was deceived in making payment to the tune of 6.8 million naira as backlog salaries. The dependent stopped payment when audit department raised query as to the payment of the backlog of salaries to a retired staff. The dependent's counterclaim for the sum of counterclaim for the said sum that was wrongfully paid to the claimant. In his reply to the defense and counterclaim, the claimant, the dependent to counterclaim, stated that the dependent knew they are retiring him prematurely, did not prepare their record for his retirement, and his name was not spent among those retired, and he was not given the 3 months retirement leave. He stated that he never submitted contradictory date of birth. His date of birth submitted was in his mother's statutory declaration of age, showing he was born on 18th day of February 1954. It is the dependent that created discrepancies so that they could exploit it. Prior to the legal advisor's letter acknowledging error of the college, he was invited by the second dependent for a meeting in which other dependents were present, and they all acknowledged their errors and pleaded with the claimant's lawyer for time to pay the claimant backlog of his salaries. The letter from the legal advisor was not forged, and the signature on the document is genuine. He also stated that he was threatened if he did not write the procedure for his payment of pension gratuity will not be commenced. He stated that he did not submit statutory declaration of age bearing 18th day of February 1954 as his date of birth. The said document was doctored by the counter-claimant. The claimant, dependent to counter-claim, stated that he did not forge letter, neither did he collude with anybody nor deceive anybody to start payment of the backlog of his salary. The payment was made after his lawyer has written severally to the dependent. The payment were his statutory entitlements, which were not erroneously paid, but paid after all verifiable factors were considered by the dependent. The counter-claimants cannot turn around to claim that the monies were wrongfully paid. The submissions of the dependent ROS of Beche counsel for the dependent, who franked the final written address of the dependent in oral adumbration, informed the court he is adopting the final written address of the dependent as his argument in this matter. He also informed the court that they have formulated 3 issues for resolution. The 3 issues have been captured and the argument advanced therein, so I am skipping that. I go to the submissions of the claimant. I.M. Anana Esquire appeared for the claimant, holding brief of C.J. Ijere Esquire. In oral adumbration, he adopted the final written address of the claimant as his argument in this matter. Counsel also informed the court that there is only 1 issue for resolution. The argument on the single issue has been captured in the body of the judgment, so I will skip reading it. The dependent also filed a reply on point of law. It has also been reflected in the body of the judgment, so I will skip reading it. I go straight to my decision. I have considered the processes filed in this suit, the evidence led by the parties, the final written address, as well as I have also listened attentively to the oral submissions of counsel adumbrating their respective final written addresses filed in support of the case for their client. The facts constituting the basis of this complaint have been stated earlier in the earlier part of this suit. So there is no basis to restate those parts again. It has been established by a long line of decided cases that burden of proof in civil cases and in the case at hand rests always on he who asserts. Therefore, the burden is on the claimant in the instant case to prove that he is entitled to the reliefs being sought. It is when the claimant has adduced sufficient, cogent, credible, and admissible evidence establishing his claim that the burden shifts to the defendant. This is because the burden of proof in civil cases or matters is not static and may shift in the course of proceeding in a case, depending on the state of pleading at various stages. The initial evidential burden of introducing evidence to prove claim to a legal right or liability based on assertion of facts upon which right liability is claimed is placed squarely on the shoulders of the claimant or he who asserts, and until it is satisfactorily discharged on the balance of probability or preponderance of evidence as required by Section 134 of the Evidence Act, it does not shift pursuant to Section 133 of the Evidence Act. In this case, the claimant is the one that desires this court to enter judgment in his favor. Therefore, he is the one that bore the initial burden of proving the facts he asserted on which he based his claim. If judgment is to be entered in his favor, see the case of Adegoke versus Adebi, Abu versus Inaji, Oyobare versus Omorabo, Ogboboja Ike versus Ogboboja, Omobreke versus Isegine, and host of other cases cited therein. What emerges from the above cited cases is that the burden of proof in civil cases is recognized to be in two tranches. The first being the legal burden and the second the evidential burden. The legal burden is always on the claimant, that is to prove the claim he brought before the court, while the second burden is the one that steals from one side to the other depending on the state of the pleading. In the case of Ogule versus Anpa Abutu Cooperative Group Farming Society versus Nigerian Agricultural and Cooperative Bank. See also Indul versus Wayo. From the 8 reliefs being claimed by the claimant, the first, second, and third reliefs are declarative, aimed at nullifying the retirement of the claimant from the service of the defendant with effect from 18th day of February 2017. The first relief is for payment of the sum of over 3 million being unpaid salaries and allowances for 7 months. The fifth relief is payment of 1,800,000 naira as financial difference between 64 and 68% of final emolument of pension for pension. While the sixth relief is for the 20 million general damages, there is also 3 million being cost of dispute and 10% for the 10% of the total judgment sum from delivery to liquidation. It has been decided by a plethora of judicial authorities that claims before the court are circumscribed by reliefs being sought, and the claimant's duty is to lead such evidence as would establish his claim only, and the defendant's duty is to plead such facts as are necessary for his defense, or as would establish his defense. TKPL Metal Nigeria Limited. Also Egonu versus Egonu. Also Obioma versus Olomu. Also Elumezi versus Elumezi. Also Chief Registrar versus Vamos Navigation Limited. Going by the reliefs 1, 2, and 3, the claimant is praying for declaration of the facts abide in the pleading, which is a witness in the witness statement of facts in proof of this declaration, and to the effect that the claimant joined the services of the first defendant in 1990, he assumed duty on the 3rd of April 1990. In 1992, his appointment was confirmed, but he could not locate his letters.
My Lord, I can no longer hear you, sir. My Lord, with respect. Okay. Very well, sir.
He included a photocopy of record of service, which he also front-loaded and attached to his statement of facts. He also stated that he submitted a statutory declaration of age declared by his mother, affirming his date of birth to be 18th day of February 1994. He bleeded the declaration of age by his mother and front-loaded it, but never tendered it in evidence that he received a memo from Deputy Registrar Pension dated 19th day of January 2017 requesting for information on his correct date of birth. He replied stating the date of his birth as 18th day of February 1954. The pension unit rejected the response and ordered him to file his letter of retirement as he had clocked 65 years of age on 18th of February 1954. According to the claimant, he was threatened with dismissal if he failed to file the letter of retirement. According to the claimant, he was prematurely retired from service. As a result of his premature retirement, his pension was calculated based on 64% instead of 68%, thereby shortchanging him. Consequently, he filed petition to the ad hoc committee of the financial transaction on his unjust retirement. He also served dependent demand notice a reply by letter 18th day of March 2019. Dependent acknowledged their error and started payment of his withheld backlog of his salary, but abruptly stopped after paying 6.8 million naira. The dependent on their part insisted the retirement of the claimant as at 18th day of February, the claimant as at 18th day of February 2017 had clocked 65 years of age based on the date of birth which he submitted when he was employed, and the date of 18th day of February 1954 was the date contained in his curriculum vitae submitted to the dependent. According to the dependent, the claimant subsequently, in order to extend his stay in service, brought a declaration of age purportedly made by deposed to by his mother, stating his date of birth to be 18th day of February 1954. The dependent also stated that the letter from the legal advisor based on which payment was made to the claimant was concocted and made without authority. It is clear from the facts of this case that the bone of contention centers on the alleged premature retirement of the claimant from service. To find out whether the retirement of the claimant was premature or not, the correct date of birth of the claimant has to be ascertained, because it is the date that will determine when the claimant would have been due for retirement in line with the extant provisions of the law and by provision of the law as section 14.4.1 of chapter 14 of the revised condition of service exhibit D1 provides that the compulsory retirement age of staff shall be 65 years. The claimant insisted he was born on the 18th day of February 1954, as according to him, he submitted a statutory declaration of age by his mother. He also insisted that the date of 18th of February 1954 was the date contained in his record of service, which he front-loaded. He also relied on Exhibit C9 letter of the defendant's legal advisor acknowledging error and which kickstarted payment of his salaries as backlog of salaries. As pointed out earlier, the first, second, third, and third reliefs being sought are declaration, which by law the burden of proofs on claimant establishing declaratory reliefs to the satisfaction of the court is a very heavy one, in the sense that such declarations are not granted even on admission of the defendant, where the claimant fails to establish his entitlement to declaration by his own evidence. In other words, a declaration of right as sought by the claimant against the defendant cannot be made on admission or in default of pleadings by the defendant or reliance on evidence of the defendant witnesses, but only if the court is satisfied by evidence that he is entitled to such declaration. In law, a claimant has the onus of proof on him to show that in a declaratory action he is entitled as per his claim. In this regard, he has to succeed on the strength of his own case and not on the weakness of the defendant case, where the default in discharging this onus, his claim will be dismissed. See the case of Kodinlie versus Odu, Adele versus Oebade, Mutwanshe versus Shorube, Dumes Nigeria Limited versus Nwakoba, Eco Bank Nigeria Limited versus Monye. In the case at hand, despite the dispute would have been easily settled if the claimant had produced his certificate of birth, which in law is conclusive proof that the person named therein was born on the date stated, and the parents are those spelled out in that document. It does not really matter the person who gave the information for the birth certificate to be issued, whether it was the father or the mother or the respondent who gave the information. The fact remains that an authorized person issues the birth certificate. This did not happen in this case, as there was no birth certificate tendered by the claimant before the court in proof of the date of his birth. Therefore, the claimant has failed to prove his date of birth by conclusive evidence. See the case of Okelola versus Adeleke. See also Cardoso versus Daniel. See also Ukeje versus Ukeje. See also Olaya versus Olaya. See also Chidulo versus Atanse. Notwithstanding the absence of birth certificates, the law has also provided other means of establishing a person's age or date of birth in the absence of presentation of a birth certificate in a court or in a court. The law is well settled that age or date of birth can be established by evidence of a person who saw the birth or had the knowledge of the birth. This must be somebody who is older than the person whose age is determined by the court. See Gusau versus Akpata. See also Agwasim versus Eji Bumerewej Umejiwaye. The claimant, despite pleading the statutory declaration of age by his mother to support his claim that his date of birth was 18th day of February 1954, failed, neglected, and refused to tender the said document in evidence. He rather chose to rely on Exhibit C9, which the defendants are contesting its authenticity. That's why when it was tendered, why they informed the court that they will address the court on the way to be attached to it, which they did in their address. The statutory declaration of age, which had been front-loaded by the claimant, which despite it being pleaded, the claimant failed and refused to tender same in evidence. It is still in the record of the court attached to the statement of facts as one of the documents the claimant intended to rely, but he failed to tender it for the reasons best known to him. I have thoroughly examined that statutory declaration of age, which was attached to the statement of facts filed by the claimant himself, It was said to have been made by one Mr. P.U.S. Unkocha, a native of Omukwa in Abiam Owerri, local government area of Imo State, who is a Christian and a farmer, who reside at Umokwo in Abiam Owerri. The said statutory declaration of age was said to have been deposed by deponent on the 30th day of October 1999 before a faceless notary public. The purported statutory declaration of age was sworn at Abakaliki in Ebonyi State and not in Owerri, where the purported deponent claimed to be living. It is evident from the purported statutory declaration of age that the said declaration of age was not made by the mother of the claimant, as claimed by the claimant, as Mr. is not the same thing with Mrs. or Miss, and she cannot be the same. They cannot be the same. What even made the purported statutory declaration of age, which the claimant has heavily relied on in his pleading in making his case, but which he failed to tender, was that purported declaration of age before the notary, faceless notary public, was made 7 months after resumption of duty of the claimant. The claimant, according to the record, he resumed duty on 3rd of April 1990, while the purported declaration of age was done on 30th day of October 1990, which shows that as at the time of resumption of duty, the purported declaration of age, which shows that the claimant was born in 1954, was never in existence. So it could not have been submitted by the claimant as claimed by him to the dependents as showing evidence that he was born on that date. The date on which the purported statutory declaration of age was sworn before the faceless notary public still remains 30th of October 1999, as it can be seen on the page of that document. That is 6 months after claimant had resumed and started work and be collecting salaries from the first dependent. From the foregoing revelation, from a careful perusal of the purported statutory declaration of age, which the claimant refused and failed to tender despite pleading to rely on it, I have no difficulty in coming to the conclusion that the claimant knew that his claim regarding the 18th day of February 1954 was baseless and without any foundation. That's why he deliberately refused to tender the said purported statutory declaration of age. The claimant, in his pleading and his statement on oath, insisted that he never submitted statutory declaration of age by his uncle when he resumed work, but under cross-examination, he accepted that yes, his uncle swore to birthday declaration, stating that he was born in 1952, which is the date which the dependent are claiming as his date of birth. He also agreed that the declaration sworn by his uncle was in 1983, long before he was employed by the dependent. He also agreed the declaration by his mother was in 1990. He stated that the declaration by his mother was the authentic one. However, it has been proved that that declaration, which he claimed to be authentic, was not actually in existence when he resumed, so he could not have submitted it to the dependent for the purposes of his date of birth. Coming to the Exhibit C9, CW2 in his testimony stated that he authored Exhibit C9 on the directives of the registrar. Under cross-examination, he agreed that the letter has no reference number and that it was written on the directives, which was the claimant, which is in the claimant file at the college. The letter was written officially. A careful perusal of this XBC9 will clearly show that it has no reference, which is against normal way in which official correspondences are made. between agencies of government and outsiders. Secondly, the author said he was writing on the directives of the registrar of the college, but there is nothing to show that he signed that document for the registrar. He signed that document for himself, and he must he must claim the ownership of that document. It is indisputable that the registrar of the college is the authorized officer according to law to issue such kind of letter. I have also noticed alteration in paragraph 2 of the said document where letter D was written with a biro and there was no signature of the person that altered the said document to authenticate the said alteration. These lapses in Exhibit C9 has rendered Exhibit C9 weightless and has no evidential value before this court, and it is hereby discountenanced for the purpose of this judgment. In view of the failure on part of the claimant to adduce evidence in proof of his case, there is no burden on the defendant to adduce any evidence. In the circumstances, I accept the claim of the defendant that the claimant was born on the 18th day of February 1952, and by operation of law, he is deemed to have retired from service on 18th day of February 2019. Even without tendering any letter of retirement, the law has deemed his employment as at an end when he clocks 65 years of age on the 18th day of February 2017. In view of this, no one can extend his service to 2019 as being purportedly done by Exhibit C9. His Exhibit C9 is therefore null and void and of no effect whatsoever for having contravened the clear and uncontroverted provisions of the law. It has no evidential value to prove anything in law. In view of my finding that the claimant has not, as at the time of his employment, submitted statutory declaration of age, putting his date of birth to be 18th day of February 1954, all his claims failed, like pack or pack cards, and same must be dismissed for lacking in merit. No letter requesting him to proceed on. The claimant has also made heavy weather on the dependent not serving him with 3 months notice of retirement from service or allowing him to allowing him to be enrolled for retirement exercise. The claimant's complaint as per his pleading and Exhibit C7 is unnecessary, as it is not the responsibility of the dependent to kickstart the process of retirement of a member of staff or the claimant. The rules mandated the employee himself to give notice of his impending retirement. See Section 12.2.15.1 of Chapter 12 of Exhibit D1, the revised condition of service, which all the parties agreed as the conditions of service that govern the employment of the claimant, which provide that retiring staff is required to give 3 months notice to retire from service of the college before the effective date of retirement. Within three months, the staff should proceed immediately on a mandatory 1 month pre-retirement workshop seminar. Then the remaining 2 months, the retiring staff is expected to take necessary measures to put his record straight so as to facilitate the speedy processing of his retirement benefit. It is clear from these provisions of the law that the duty or the responsibility of giving notice of retirement falls squarely on the shoulders of the claimant and not the dependent. The claimant has no basis to blame the dependents for rather he has to blame himself for not doing what the law requires him to do, which led him to find himself in the quagmire which he found himself in. Even if the claimant has basis to complain, Exhibit C7 relied heavily by the claimant to make this complaint has no evidential value, as there are so many alterations and cancellations in that document which has not been authenticated also, that has rendered Exhibit C7 to be worthless and not having any evidential value, and it cannot be used for the purpose of this judgment to prove anything, and it is hereby discountenanced. I must at this juncture state that the drama played by the claimant was deliberate for him to gain financial undue advantage that he is not entitled to, as per the insistence that he must be paid backlog of salaries when the law has retired him as far back as 18th day of February 2017. From all I have been saying above, the claimant has failed woefully to establish his claim that he was born on the 18th day of February 2018. Consequently, having not been entitled to declarations 1, 2, and in his reliefs 1, 2, and 3, he is also not entitled to all the other reliefs from reliefs 4 to 8, as all those reliefs are dependent on the declaration, on grant of the declaratory reliefs. The declaratory reliefs having failed, which are the main reliefs in this case, also the appendages, that is the other reliefs, also fail, and all the reliefs are hereby dismissed for lacking in merit. I now come to the counterclaim. In the counterclaim, the dependent counterclaimant is claiming for the sum of 6,859,515, 10% interest, and 1 million naira general damages. The law is right that a counterclaim is a separate and independent suit of its own. Therefore, just as the claimant has the burden of proving his case to be entitled to grant of same, the dependent counterclaimant also must adduce sufficient, cogent, credible, admissible evidence in support of his counterclaim. See the case of UAC Nigeria Limited, PLC versus Eunice and Akinyele. The dependent counterclaimant in the counterclaimant are relying on several documents in proof of their defense and counterclaim. However, they were only able to have one document admitted in evidence, that is revised conditions of service for colleges of education 2015. It is clear to me that the counterclaim being claimed for salaries that were paid, which the claimant has admitted, which the claimant has admitted receiving in his pleadings, has been proved as facts admitted need not to be proved again in the circumstances and in view of the admission of the receipt of the salary based after the retirement, after the statutory retirement of the claimant from the defendant, which was made to him based on spurious advice by staff of the defendant, he is not entitled to retain those amounts. In the circumstances, the claimant is hereby ordered to refund the salaries which he has received, which he is not entitled to, in the sum of 6,859,515,000 naira. It is clear to me that before I end this judgment, let me hasten to state that looking at the quality of the processes filed by the parties, which are replete with grammatical errors and avoidable erratum, there is need for counsel to be more circumspect when ranking court processes. This is more so when considering the fact that we are in a global village where whatever one does is being watched all over and is being followed. All the counsel in this case are guilty of this lack of circumspection. Counsel should know that by their calling, they are expected to be diligent in ranking court processes. This case is also a reminder that counsel accepting briefs should always have at the back of their mind that counsel are not immune from being pursued for negligence in rendering services to their client. I see no reason why in this era, when public documents are rejected by a court for not having been properly certified, counsel will relax and step back and resign to his fate without ensuring that those public documents are those public documents which need to be brought to the court are properly certified and brought before the court for court to do justice to the parties. From the foregoing and reasons given in this judgment, I have come to the conclusion that both the claimant and the defendants, counter claimants, I come to the conclusion that the claimants in this case has woefully failed to prove entitlement to any of the reliefs being sought. Consequently, the claim of the claimant is dismissed, while the claim of the counter claimant, having been admitted by the claimant, succeed, and same is granted. The counter claim is hereby granted. I make no order as to cost. Judgment is entered accordingly. Call the next case.
Suit number NICN DK01-2019, opinion. And one, Cross River Basin Development Authority. My Lord, parties are present. Your name, sir? J.O. Kano. Your position? Admin officer of the defendant matter. Claimant in court.